Now from our reporter, that's our senior politics reporter, Ziyanda Ngcobo. Ziyanda, there's about 9 elements to this judgment. Take us through the key elements of it.
Well, Toli, look, judging from what Judge Piet actually handed down, it seems as though he has found a balancing act, and I wouldn't say there's an outright win for either of the legal teams. I'll tell you why. In essence, what Judge Piet has just said is that, look, the matter will be postponed to the 10th of August. When the matter resumes on the 10th of August, we'll still continue with hearing that special plea to have Billy Downer recused and ultimately perhaps former President Jacob Zuma acquitted, and that will still take place virtually. But in the meantime, the parties, that being former President Jacob Zuma's lawyers, as well as the Correctional Services Facility, are now being asked to write in no more than 2 pages how the former president would be prejudiced if he has to continue doing this or having this matter heard virtually, subsequent to that decision not being revoked. I think what the judge was trying to do was to actually find a way in which, firstly, the issues of having access to former President Jacob Zuma are dealt with, but also then at that stage, perhaps, Koli, the lockdown regulations would have, been loosened, so to speak. But I'm not the expert, Koli. I'm actually joined by Mpumelelo Zikalala. You've joined us yesterday. You're back with us, today. And when we hear what Judge Piet said, why would he postpone it to the 10th of August if he's still saying that even when the matter returns on the 10th of August, that special plea will still be heard virtually?
I think it's to give assurance, and also for him to get assurance that the modes of communication between the legal representatives of the former president, the facilities at escort are well and they are sorted out. So there will be no break in communication. They'll have access in terms of communicating with him and getting instructions. But the most important one, let's also remember that yesterday there raised an issue that we've only had 1 session in which we consulted. It was a marathon consultation. There may be other issues that we hadn't canvassed and we want to deal with them. Can you please have access to our client? So this particular period will then allow the former president team to go to escort or to consult in any other means, even virtually, so that they have full and proper instructions as to how this particular matter should be handled. I must raise this concern, though. I stand to be corrected. The current regulations, as issued by the Department of Justice, limit access to courts. And it had a bit of a problem when it comes to legal practitioners accessing prisoners which are in court. Now, the question would be, are we creating special rules and special directives for the former president, or is it going to be open and accessible to all? Meaning that if I have a client at the Westfield prison, I now have the ability to go there either virtually or physically, consult with them so that I'm able to proceed and protect his rights and get full instructions when I go to court on the next occasion.
But then that raises the question as to how the former president's lawyers had access to Zuma last Thursday on the 15th of July when the Jacob Zuma Foundation tweeted that they went to go see him. So in other words, as you're mentioning then, is there a special treatment now that's been given? Because I know that Advocate Thabani Masuku raised this to say, why not just wait, just like everybody else? Because all other trials have actually been put on hold as a result of the lockdown level 4 regulations.
In fact, that's the type of question in which one would raise in terms of saying, currently, yes, again, I stand to be corrected. You can't go to Westfield prison as a legal practitioner. So in these instances, are we then creating new rules? But the question in terms of saying, let's wait, I would say the important part is to look what type of action or application are we looking for? What type of proceedings are we going to deal with? In this case, it is purely arguments which are going to be led by legal practitioners. The accused person or the former president is not going to go on the stand. There is no witness which is going to go into the witness stand. So the questions about checking the demeanor, cross-examination, and the stance of the court, they're not going to be in question in this case. It is purely legal arguments. So what we had yesterday is exactly what's going to happen in a couple of days' time, and there's no real involvement or active participation of the former president. So the step of going virtually with this particular application, not the main trial, must be commendable, and I must say It takes us a step forward in terms of developing our legal system and the way in which our courts function by saying, let's look at the times in which we are dealing with. We have the pandemic, we have technology that you can use. Let's get justice out there to the people. While doing that, we are well cognizant of Section 35 of the Constitution that the trial must start and end within the shortest and reasonable amount of time. That's what we seek to do by engaging in this. And I must say, it is quite a balanced judgment. It's very rare to say this, but I think both parties at the end of the day, they've got something, they've won something out of this whole process.
And I mean, I suppose if you say both parties won, this judgment also confirms that in no way will the NPA be prejudiced by this delay. And I'm asking this because we know how difficult it is to get any matter on the court's roll. And this matter was set down for a term and a half. And we've constantly had these delays. And you've just mentioned concluding a trial within the shortest possible time. So I suppose can the NPA also then say that this won't prejudice their case in any manner, given how long it's taken for it to even be put back on the court's roll?
Certainly they will raise that argument, but the ultimate one would be this. In doing whatever that I'm doing, am I able to protect the rights and the interests of the accused? If the answer to that is yes, I would rather suffer a delay of maybe a week or two compared to the contravention of the rights of the former president. That can't be allowed and it shouldn't be allowed. And the safeguarding of that is evident in the judgment of today, because it then says, I'm well aware of your rights, I respect them fully, but I need to do a job here. My job is to adjudicate on this matter and make sure that I'm able to hear you. This is only the start of a number of cases or proceedings which are going to come at the end of the day. Let's deal with it now. I want to make sure that we start with the actual trial, with the merits of the case. Let's get the first, second, and third witness into the box so that we're able to come to a verdict at the end of the day.
But the complication here, Mr. Zikalala, is that the former president is currently serving a 15-month jail term sentence. So let's say, the virtual proceedings for that special plea are heard, the judgment will be reserved. Who's to say that when the trial actually goes ahead, when he needs to be there in person, that won't happen within a time frame within which the former president is still incarcerated? What happens then?
There's certainly that possibility, and it's going to cause a lot of disturbance when it comes to the manner in which the proceedings are going to move. Let's remember, each time the former president goes out of escort prison and comes back, he has to go into isolation again. There's also issues about consultation and all of that. Now, they may have to come to another provision or another arrangement once the trial has started of saying, this is how we're going to proceed, because the way in which Judge Kun is handling this particular matter, he seems determined to say, I'm not going to waste any time. I want to make sure that I run this court efficiently, but while doing that, I want to protect the interest and the rights of both parties. So we may have see a situation when the actual trial starts, there are another special arrangements that must be made to make sure that the trial is able to start and end within the shortest amount of time. But it's going to pose a bit of challenges in terms of making sure that all of those processes are done without the courts and the legal system seems to be biased or to be promoting or protecting only the interests of the former president compared to other accused that are in prison or waiting trial persons whose matters must go in front of a judge or a magistrate and be adjudicated.
Certainly not an easy one here. That's Mpumelelo Zikalala. He is, of course, a legal expert there, Koli, really unpacking the implications of what's going to happen on the 10th of August. But even beyond that, given then the fact that the former president is currently incarcerated, and so there are certain arrangements that need to be made. But again, the question is a former president, Jacob Zuma, being treated with kid gloves in a special manner, in the sense that he is now also going to have separate arrangements made in order for his matter to go ahead?